So the days of simply telling people, trust me, I know my stuff, are over. Nor should they be. If you're asking people to trust you with one of the most important battles of their lives, you should be prepared to show them how you think, not just tell them you're the expert. And that's exactly why I've decided to start sharing my daily journal every day in words on Facebook, LinkedIn, and by video on YouTube. And here I'll be sharing my thoughts, analysis, and learning, not because I think I'm always right, but because I want prospective clients and service users to see my actual thought process, the way I analyze family law, the questions I ask, the connections I make, the strategy behind the advice. I want people to judge me on the quality of my thinking, not on marketing slogans or self-proclaimed titles. I've devoted the last 15 years of my life to one very specific area, family law and the family court, not just studying it for my own benefit, but helping thousands of other people navigate it too. This isn't just a job anymore. It's become part of who I am. Very few people can honestly say they've spent as much time obsessing over one niche, constantly learning, constantly questioning, and constantly trying to improve. I'm also awaiting the results of my adult education studies alongside everything I've taught myself over the last years. Personally, I think lived experience, relentless study, and thousands of real cases teach you far more than a certificate ever could. But people like certificates, so we get the certificate too. And when that's done, no doubt someone will find something else to complain about. That's life, and we move on. But that said, the bigger point is this. I'm putting my thinking out into the public domain every day. That means people can challenge it, question it, learn from it, disagree with it. It also means there is a complete transparency. You won't just see my conclusions, you'll see how I got there. If you are a professional working in this field, you may even see your name. You may even hear it spoken about if our paths cross professionally. Not as a personal attack, but because discussing ideas, discussions, and professional standards openly is how sectors improve. I also think something else will happen. People will begin to see the difference between original thinking and recycled thinking. Too many people simply repeat what they've heard from someone else. They quote guidance without understanding it. They repeat clichés without questioning them. They adopt opinions because they're popular, not because they've reasoned them through. I've never been wired that way. I'm a free thinker. I question everything. I don't accept something because someone with a title says it's true. I read it, I test it, I challenge it, I compare it with the law, psychology, real cases, and real outcomes. And then I form my own view. And that's what I'll be sharing, ultimately. Not just the answers, the thinking behind the answers. And I suspect that over time, others will start doing the same, because once people can see how someone genuinely thinks, it's much harder to hide behind buzzwords, borrowed opinions, or self-appointed expertise. So we'll start today, 11th of July. First thought this morning was CAFCAS is making child-focused courts more essential priority. This is pathways and the changes that CAFCAS are making. The biggest structural change in the family justice system remains the national rollout of child-focused courts. CAFCAS has now embedded the program within its 2026 and 2029 strategy, aiming to identify harm earlier, reduce delay, hear children's voices sooner, and improve outcomes, particularly where domestic abuse is alleged. Now, the real implications of this, the lessons we can take from this, or what we can do with this, is under the child-focused courts model, evidence should be presented in a way that helps the court decide that what order best promotes the child's welfare, safety, stability, and long-term needs. That does not mean parental behavior is irrelevant. It means parental behavior should be shown in terms of its impact on the child, including emotional well-being, risk, relationships, education, day-to-day routine, and practicality of any proposed arrangements. Every piece of evidence should help answer one question. How does this help the court make the right decision for this particular child? If you can answer that throughout your position statement and witness statement, you're thinking in the same way that the court is increasingly being encouraged to think. Private law demand continues to increase. Now, this is what was really bizarre. Latest CAFCAS figures show private law children's cases are up 9.3% compared to the same period last year, with overall children's cases demanding increase by 6.1%. Open private law cases have also risen significantly. This isn't just reflected in the courts. judges and CAFCAS officers are carrying heavier caseloads, meaning they have less time to work through poorly prepared evidence. The people who present clear, concise, well-organized material are increasingly giving themselves the best opportunity to be understood. More paperwork doesn't necessarily mean stronger case, but better paperwork does. The more I learn about the Mackenzie Friend marketplace, the more certain things begin to make sense. People are actually paying for leads. Think about that for a second. Litigants who are often desperate, looking for help, and many of them seem to end up in the same handful of websites, such as findermackenziefriend.com and Phil Kedge's Mackenzie Friend UK network. From there, it appears they're directed towards professionals within those networks. That deserves far more scrutiny. It would also explain why there has been so much effort to discredit me. I don't play by the same rules. I don't buy into these little schemes of self-appointed authorities that present themselves as regulating an entire unregulated profession. They have no authority over me because I don't pay into their little clubs. The findermackenziefriend.com situation is a good example. I removed myself from the website. I wasn't banned, yet my profile was later put back on there and labelled as banned. Those are two completely different things. If a litigant sees that before they've even spoken to me, what impression does that create? The more I look at it, the more the pieces fit together. It would certainly explain why professionals appear to keep so keen to smear me. If you're not part of the system, if you're not paying into it, and if you're doing things differently, you're unlikely to be welcomed by those who benefit from it. Phil Kedge has rightly spoken about raising standards and criticising poor practices elsewhere. I agree to that standard. I agree that standards matter. But if we're going to demand transparency from solicitors, then the same transparency should also apply to anyone in the Mackenzie Friend sector. And that includes Phil Kedge. Yes, I profit from it. I've never pretended otherwise. But I believe people should be paying for quality, strategy and results, not because somebody has bought their way to the front of the queue. And this is the point. I wonder if these litigants know that Phil Kedge, who's so against solicitors for the fees that they charge, he's actually using your litigant lead and making money out of it twice, 3 times, 4 times. They're selling the same leads to different people. That's what I'm saying. And it's sick. And you're going through enough as a litigant, and people are signing up to these websites thinking because he's a police officer or a former police officer that he's noble. It seems anything other, but we'll keep looking into that. Child-focused courts continue to replace adversarial hearings. That's true. The Ministry of Justice Reform Programme continues moving family proceedings away from traditional adversarial litigation towards earlier problem solving. Child impact reports and more robust safeguarding assessments. Early pilot areas reported shorter case durations and reduced backlogs. I can confirm that to be very true. The practical implication of this, in practice, it means that parties are usually better served by presenting realistic, child-centered proposals supported by evidence of cooperation where it is safe. Safe and genuine. That said, cooperation is not a substitute for safety, and the court will still focus on welfare, risk, and what arrangement is best meets the child's needs. For example, a parent does not gain credit for agreeing to an arrangement that places a child at risk simply to appear cooperative. Genuine cooperation is encouraged, but never at the expense of safety or welfare. The court's primary concern remains making the order that best protects and promotes the child's long-term interest. Family law update: relocation cases still hinge on welfare. Recent family law reporting continues to show courts refusing relocation applications where the evidence suggests that a move would undermine child's stability or relationship with the other parent. Welfare remains the overriding consideration rather than either parent's personal preference. Now, relocation applications succeed only where there is evidence showing that the move will genuinely promote the child's welfare. The court will expect detailed, realistic proposals covering schooling, housing, travel, contact arrangements, support networks, and child's long-term stability. A parent's improved personal opportunities may be relevant, but they are not enough on their own. The focus remains on the child's welfare and the likely impact on the child's relationship with the other parent. What everyone else is missing. The direction of travel in family law is becoming increasingly clear. Well, it is to me. Whether you are preparing a C100, witness statement, or a position statement, or responding to CAFCAS, the winning strategy is no longer to prove the other parent is a bad person. It's to demonstrate with evidence why your proposals are the ones that best promote the particular child's welfare. Parents and professionals who understand that shift will now be better prepared than those still fighting yesterday's battles. Let that be a lesson to everyone that's watching this and everyone that I'm working for. You will not get anything from fighting and proving who is the better parent. They do not care unless it puts the child at risk, which they do. Now, the good people will take this and you'll spread that message because love always wins. And I'm telling you now, this is what I've been doing for years. And this is why I've been having the success that I have. Eat me.